Hi, everyone, and thank you so much for joining me this morning for our presentation on mandamus lawsuits. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC in New York City. It's a pleasure to be with you all. Today, we're going to be really kind of skimming the surface regarding what mandamus lawsuits are, the process of filing them, when they're appropriate, and why they're such an important tool in U.S. immigration practice. The short summary is that a mandamus really has become one of the most powerful and effective ways to address a delay on an immigration-related case. So if the government is taking a very long time to decide a benefit, whether that's a work permit, whether that's an application for a green card or an application for a temporary visa, or even an application that's at a consulate, a mandamus is oftentimes the solution to address that. To give you a bit of background about our firm and to go over a few housekeeping items, this presentation is being recorded. We will share with you after this presentation a link where you can access the recording. We do post our webinars as well as a variety of shorter videos to our YouTube channel. We do hope you'll check out our YouTube channel. Our firm practices not just litigation and not just business immigration, but also family-based immigration. And we handle temporary visas like student visas and visitor visas. We really do address the full spectrum of US immigration law. So we're proud to put out information on all those options on our YouTube channel. So please do check that out. In that email, we'll also have a link where you can sign up for future webinars. Again, those run the full spectrum of US immigration law. And there's a link in that email to our blog. Our blog, we're very proud of it. We regularly post to our blog. And again, we try to put the best information that's available, again, really informed by our practice. So we hope you find that helpful. Our firm, like I mentioned, does handle the full spectrum of immigration, though I will say that what I think really makes us stand apart from other immigration practices is the fact that our founder, Ian Scott, has personally navigated the process. He is currently on an E-2 visa. Our firm was founded on an E-2 visa. Before that, Ian navigated the TN visa, the H-1B, the F-1 student visa. So he really has personally and firsthand experience the US immigration system, and that informs the way that we work with our clients and help them navigate the process. If you do have questions during the presentation, I do plan to get to all questions, so please don't hesitate to send those in. You can do that using either the Q&A function on Zoom or the chat function on Zoom. So don't hesitate, again, to send in questions. There's a good chance that I'll save those for the end of the presentation. But again, send them in. I do plan to get to all of them. So with that, let's go ahead and dive in. So to start, what is a mandamus action? So mandamus is a word that we don't usually use in English, but really what it is an order from a judge telling the executive branch to do its job. So the US government system, the constitutional system we have, is one of three branches of government: executive, legislative, and judicial. And mandamus is basically when the judicial branch is telling the executive branch to do something that it is required by law. So in the context of immigration, that's exactly what it is an immigration benefit is requested. That would be requested of the executive. The executive oversees consulates. The executive oversees U.S. Citizenship and Immigration Services, which is the agency within the U.S. that decides benefits. So if USCIS or a consulate is not doing its job, in other words, not deciding, for example, whether an application should be approved or denied, then we have the option of going to a judge in a district court and saying, "Judge, please ask the executive, please order the executive to do its job." And we have had great success with these cases. They are not unusual. And frankly, Internal communications within the government shows that in some ways the government sees mandamus lawsuits as in some ways the expected pathway to an expedite request. For better or for worse, uh, unfortunately, litigation, we will talk about this. Litigation is time consuming. It is typically not cheap, but because the executive branch, the immigration agencies are seeing so many applications, because their internal procedures have really slowed down processes, delays are growing and growing and growing. So these lawsuits are becoming more common. And in some ways, the government simply won't respond to an expedite request unless it's in the form of a lawsuit. So importantly, a mandamus action is not asking a judge to make the government approve an application. Uh, what it is asking the judge to do is to tell the government to do its job, to reach a decision. So this is very important. You would not file a mandamus lawsuit if your application has been denied and you want to challenge that denial. You can file such a lawsuit. It's just not a mandamus lawsuit. It's not what we're talking about today. That would be a lawsuit where you're challenging a decision. What we're talking about today is where there has not been a decision on your application, and you're asking a judge to tell the government to simply reach a decision. Now, that decision could be an approval, but that decision could be a denial. And that decision could also be a request for additional evidence. What we would usually do if the government does issue a request for evidence is we'd typically keep the case open with the judge and make sure that the government, after you have responded to your request for evidence, that the government then again responds to that information in a timely way. And if they don't, we still have the case open with the judge, and we can go to them if the government continues to delay. And as I mentioned, a mandamus action can be filed against basically any government entity, whether that is U.S. Citizenship and Immigration Services, a consulate, or other government entities that have a duty or an obligation to act. Just as an example, if there is a delay at a consulate, oftentimes the consulate will say, well, it's not our fault. The issue is that this application is undergoing a security review with the FBI or the CIA. So in those cases, we would sue not just the consulate, not just the Department of State, but also the FBI, the CIA, whoever it is that is doing the reviews, so that they know they need to do their job. So you really can cast a broad net here if the government is kind of obscuring the reason for the delay. Mandamus actions can be used to compel or make the government act on a variety of petitions. So that can include an application for a work permit, an application for a visa at a consulate, an application for a green card with USCIS, an adjustment of status application, for example. So really, many applications can be addressed if they're delayed through a mandamus lawsuit. I am in this presentation going to use as my example an EB5 application that's delayed. So I'll refer to forms that are specific to the EB5, like the I-526, for example, or the I-829. Please don't get confused by that. I use that as an example, but really you can replace I-526 with any application. So if it's a work permit, an I-765. So I'm just going to use EB5 as an example because it is a good example of both what the process looks like as well as how extreme the government delays have become. So one of the most common questions we get about mandamus lawsuits is, how long do I need to wait before I can file a mandamus? We'll talk about that more. For now, the first thing to understand is that you must show the judge, you must show the court that the delay is unreasonable. So what is unreasonable? The definition of unreasonable is going to be different depending on what application you've filed. So this is the first time of many during this presentation that I will say it's important to talk with a lawyer about these cases, because the first thing a lawyer is going to do is look at the facts and figure out whether the delay is unreasonable. The first step oftentimes in determining whether a delay is unreasonable is, what does the government say is the amount of time that one of these cases should take? So you may be aware that USCIS, for example, will post online its estimated processing times for certain petitions. As an example, if you search for the I-526, again, that is the petition for an EB-5, and I'm going to do it right now. You Google USCIS processing times, choose I-526. I'm going to not choose China. I'm going to use all other countries. Right now, USCIS is estimating that it takes them 62 months to decide whether an I-526 form should be approved or denied. All right, that is over 5 years, and that is just the first step of an EB-5. Once the I-526 is approved, you don't get anything. Your green card application is considered. So that is just the first step of an EB-5, and USCIS says it takes over 5 years. So that's the first step, is, does USCIS or does the government provide an estimate? And if you've waited, say, 4 years for your I-526 petition to be decided, the government is going to take the position that you haven't waited long enough, that, well, we say it should take 5 years, you've only waited 4, therefore you need to keep waiting. And so the question is, who would a judge agree with? Fortunately, the government's processing times are only an indicator. That is not the end of the discussion, fortunately. The next question would be, what is the harm that you've experienced as a result of this delay? So you would think about things like, is the fact that my petition is being delayed keeping me from applying for a driver's license? Or is it causing issues every time I come into and out of the country? Am I going through heightened security because of this? Am I unable to travel to see my family abroad? Am I unable to work to provide for my family? All of these are things that you want to think about. What is the harm that the delay is creating? And frankly, judges, as you know, they're human. So they do want to know, what is the harm that's resulting from this delay? You really do want to emphasize that. And so even if the delay is within the standard processing times that the government states, if it's causing you real harm, there may still be a case there to be made. Typically, you do want to make sure that you've gone through all alternative steps or options before you file a lawsuit with the district court. So, for example, is there an opportunity to ask USCIS to adjudicate the application? Can you follow up with them, ask them the status, ask them to expedite? Usually it is a good idea to go through those alternative steps, potentially even reaching out to a congressperson and asking for their assistance before you file with the district court. Oftentimes judges like seeing that you've done your due diligence and taken all those steps. Although I will say that is not always required. Oftentimes that will come down to the law. So sometimes they're actually written in the law is, you need to take these steps. You need to exhaust all administrative remedies before you go to district court. That is not always said. Sometimes it is. Again, that's a helpful area where it's helpful to talk with a lawyer to figure out, what do you need to do before you file? Now, the next question and the next bullet you see on your screen is the process and the rate at which the government is adjudicating the petition, so is 62 months reasonable? This, frankly, is a very fun part of these lawsuits, because you really do have the opportunity to look at what the government has said, to look at their publications, to look at their statements to Congress, where they disclose a lot of information. And you can figure out whether, for example, 62 months is reasonable for an I-526 form. Just to give you an example, the government, USCIS, has disclosed exactly how long it takes one of its employees to decide an I-526 petition. And it is a matter of hours, not days, hours. It takes hours, a few hours to decide an I-526 petition. So that's a very important piece of information that we would put into our lawsuit when going before the judge. Your Honor, the government is saying that it needs 5 years to decide this petition that they have admitted takes hours. So it is not unreasonable for us to ask them to do their job faster. That's kind of the way that we would frame our arguments. That's the kind of information you would pull into these lawsuits. The final piece of information, which can be very persuasive, is if Congress has spoken to how long it thinks the government should take. So, for example, Congress has, for certain types of applications, for example, an application to naturalize to become a US citizen, Congress has set some pretty clear timelines. They want the executive branch to decide naturalization applications within a certain period of time. And that makes sense. They want people to be able to vote. They want people to be citizens if they're eligible. They don't want the executive branch to delay that for months or years without reason. Other types of applications, there's no specific mention by Congress about how long they expect the process to take, though I will say Congress has made a general statement about how long it does want the executive branch to take to decide temporary visas, non-immigrant visas, as well as green cards. Courts don't always defer to that general statement, but it is almost always a good idea to refer to it in a lawsuit just to show the court Congress has an expectation here, and it is far shorter than what the government is actually taking. So what is the process of filing a mandamus lawsuit? As I mentioned before, it's usually a good idea to exhaust other options, to reach out to USCIS, to reach out to the consulate, and to have records of that, the emails you've sent asking for an update, or that your attorney has sent asking for an update. Efforts by your local congressperson, or if you're wanting to start a business in the US, the congressperson where that business will be located, documents that they've tried to reach out to USCIS or the consulate to move the process forward. So once that's done, the next step is to file a complaint. So a complaint is the document that really starts the lawsuit. So what we do is we work with our clients. We find out where do they live? Do they live in the United States on a temporary visa, for example, or do they live abroad? Where will the business be if they're looking to start a business? What ties do they have to a specific state in the US, if any? And that's where we would probably file the lawsuit. We would also talk with our clients about the harm they're facing, obviously about the exact dates when the application was filed, how long it's taken, et cetera, et cetera. We would put all that information into a complaint. A complaint is a document. It lays out the law, who the defendants are, who we're suing, who the plaintiffs are, which would be the person experiencing the delay, why the court should find in our favor based on the facts and based on the law, and specifically what we're asking for. We want a decision within, say, 90 days, for example. So that complaint will be drafted, filed with the court, the district court, and typically the government has 60 days to respond to that complaint. Usually what will happen is the government, we would have to serve the complaint on the government, and so the government will be represented by the U.S. Attorney's Office, which is a division of the U.S. Department of Justice. They have very talented lawyers, which is a good thing because their lawyers do tend to be responsive to lawsuits. They want to do their job well. They also are very busy. So these are not cases they like to spend time on. So they want to resolve the case. What that means is that by filing a lawsuit, you basically get a government lawyer assigned to look into your case. You have an assistant U.S. attorney who has now assigned the case. They want to resolve it. And the first thing they're going to do is call up the consular officer, or they're going to call up the officer at USCIS, and they're going to ask, hey, we got this lawsuit. What is the status of this case? And is there any way for you guys to just decide this so that I don't have to spend time on it. Unfortunately, usually the response is, we, USCIS or the consulate, we are very busy. We can't get to that application right now. You just have to fight the lawsuit. That's fine. That's what usually happens. So typically, the 60-day period that the government has to respond, we're not going to hear from them until day 58, 59. And usually what they're going to do at that point is the government attorney is going to ask for an extension, usually 30 days or so. And that is to give them time to work with their client, their client being the consulate or the government agency, USCIS, to reach a resolution if it's possible. We will usually agree to an extension because it is very, very important to maintain good relations with the government. Again, this is an attorney who is usually trying to resolve the matter. So we want to stay in their good graces. We also may ourselves need an extension. So we want it to be reciprocal. And finally, judges want to see that both sides are working together to resolve the case. Judges do not like it when both sides are arguing and not trying to resolve things themselves. Judges oftentimes think about it as kids arguing in the sandbox. You never like seeing your kids arguing in the sandbox. Just get along, play in the sandbox, and resolve it yourselves. That's what judges like to see. So that's what we try to do. I will say that even though usually the government will fight these lawsuits, there are definitely cases where they don't. If the delay is clearly unreasonable, if the delay has been longer than what USCIS, for example, says it should be, oftentimes the case will resolve. So you see on your screen, settle or litigate. What settlement means is the government says, you know what, we will decide the application. That's what settlement is in this context. That's wonderful. That does sometimes happen. And it's a wonderful thing when it does happen. More often than not, it does not happen. And what the government does is it decides to litigate. It decides to basically oppose our complaint. So what that usually looks like is the government filing what's called a motion to dismiss. And this is before they even respond to the complaint. So this is, we have filed our complaint, our lawsuit, and they respond with a motion to dismiss. And the basis of a motion to dismiss is saying to the judge, if you assume that everything, our side, you experiencing the delay, everything you have said is true, that you've experienced a delay, that you're experiencing harm, assume all of it's true, we still don't have a case. That's what the government is saying, that we would still not have a case. That's a very high bar. Because again, it allows the judge to assume everything that we have argued is true. And so it is a very difficult thing for the government to win on. Our firm has had a great success rate on opposing motions to dismiss. Again, past performance is not a guarantee of future outcomes, but these lawsuits do tend to be effective. The government, as a general rule of thumb, the government is very likely to file a motion to dismiss if you have not waited as long as the government's estimated processing times. So if your I-526 has not been delayed by 62 months and you file a lawsuit, you should expect to get a motion to dismiss in response. That's just a general helpful rule. What that means is we would have to oppose that. That does incur additional expenses. We would have to draft that response. We put time and effort into it, hence why we've been quite successful in opposing those. But that is what it means. A motion to dismiss does not mean you've lost the case. It just means we have to respond to the government's position. In the motion to dismiss, in our response to the motion to dismiss, we are really going to get into what was argued in the complaint. We're going to get into all of the evidence showing why the delay is unreasonable, all of the harm that you've experienced as a result of the delay. And we really are going to lay it all out in the motion to dismiss and argue that the judge should not dismiss this case because we really do have a basis for our argument that the government is being unreasonable in its delay and should be required to act. So let's say that we win on our opposition to the motion to dismiss. So the government has not won. Basically, almost always at that point, the government will settle. If the government loses its motion to dismiss, it usually will not keep arguing the case. And the reason for that is that if they lose the motion to dismiss, we get to do discovery. And what that means is we get to ask the government for documents. We get to conduct depositions of government officials. We really get to open their books and look at what their processes are. All of the things that they allege. So if they say, hey, there's a line and this person just needs to wait in line, we get to ask them, tell us about that line. How many people are in the line? Where does our client fall in the line? How many people are ahead of our client? The government does not want to disclose that information. And I am aware of one case where they have disclosed that information. Almost always they will say, we're not willing to turn over that information. We don't want to get into discovery. Therefore, we'll decide your application. And that's a wonderful thing. So that's settlement. Now, let's say that the government doesn't do that and they are willing to go through discovery. Well, the next step after discovery is usually a motion for summary judgment. And that is where either side, us or the government, can file a motion with the judge that says, Your Honor, we are presenting to you what has been disclosed in discovery, and you get to decide on the merits who should decide this. So this is not assuming that all of our arguments are, all of the facts we've alleged are true. That is not an assumption in a motion for summary judgment. In a motion for summary judgment, both sides are really arguing their case on paper, and the judge is looking at that and making a decision based on that. These cases, again, almost never will go to a hearing in front of the judge. They are usually decided, as I mentioned, on the papers. So each side filing its documents with the judge. For all practical purposes, though, I've said a lot on this slide. I think the important thing to keep in mind is that these cases will either settle early if it's clear that the delay is unreasonable, or will settle after the government loses its motion to dismiss. What is the actual timeline of that? You're not going to get a decision. If there's a settlement, you're almost never going to get a decision within 60 to 90 days because the government is going to use those 2 to 3 months to talk with their client. The government attorney is going to talk with the consulate or talk to the USCIS to figure out what's going on and whether this can be resolved. So you're almost never going to get a decision in the first 2 to 3 months. You may get a decision in around month 3. That would probably be the earliest if, again, it's clear that the delay is unreasonable and the government attorney and their client agrees with that. If that doesn't happen, you are likely looking at a decision after the motion to dismiss is denied, which would be, it could be a year to 2 years down the road. Judges, if the government files a motion to dismiss, judges will give several weeks typically for each side to file its papers with the court, its arguments. And then once those are filed, the judge can take 6 months, 9 months, even a year to decide the case. So again, this is not necessarily a fast process if the government doesn't settle. You can, of course, because you're the plaintiff, you can withdraw. So let's say you want to see if the government responds by settling. You can hire an attorney, file the lawsuit. It has to be a sincere lawsuit where you really do believe in the allegations. You really are willing to move forward. But if it turns out that the government wants to fight this and is filing a motion to dismiss, you can say, you know what, this is becoming too costly. I want to withdraw my case and I'll just keep waiting. That is an option you do have. I'll just quickly address something because I'm guessing that people are wondering this. What about retaliation? What if I do that? Isn't the government just going to deny? The answer is essentially no. That does not happen. There may be one example out there where there's an allegation that that's happened, but I can say from my personal experience, that has never happened. Speaking from my conversations with other attorneys who file these cases regularly, that just does not happen. I also used to be a government attorney. I used to work for the federal government. Retaliation is just not something that government attorneys do. It's not ethical. And in terms of the agencies, yes, we are seeing things under this administration that we've never seen before. I would still say that retaliation for a lawsuit would be far out of bounds of what would be allowed. And again, I just have not seen it happen. So I would encourage you not to be worried about that as a realistic outcome. So I've already really gone into what you see on this screen. We've talked about settlement. That is where the government just decides to decide your application. Again, could be approval, could be denial, or could be a request for additional evidence. Or they may decide to litigate by filing a motion to dismiss or a motion for summary judgment. And motions for summary judgment are very rare in these delay cases, again, because they allow for discovery, which the government does not want to get into. So now let's go through some common questions. I will just say we'll turn to your questions after this slide. So if you have any questions, this is a great time to send them in. Excuse me. The first question, can I file a mandamus action to make the government approve my application? You cannot file a mandamus action to make the government approve your application. Again, a mandamus action is only asking a judge to make the government decide your application. And that could be a denial, could be an approval, or it could be a request for additional information or documents, an RFE or a NOID, a notice of intent to deny. Those are all considered to be decisions. Now, again, if the government issues a request for evidence, we can ask the court to keep the case open and say, Your Honor, we haven't yet received a final decision, so please do not dismiss the case until we actually have that final decision in hand. And usually judges are willing to do that. Second, how much time must pass before the delay is unreasonable? Again, this is a very fact-intensive question. It depends on what benefit you've applied for. Have you applied for a work permit or a green card or a student visa or a visitor visa, or to naturalize? All of these have different standards, both standards in terms of how long the government says it will take, and also the laws. Sometimes the laws say something about the timeline for some benefits and not others. So whether something's unreasonable is very fact intensive. If you are wondering, we would be happy to schedule a consultation with you. Do reach out and we can talk about exactly that question as well as what harm you're facing, which does directly factor into whether a delay is unreasonable. If you are facing a critical life or death situation, if the government does not decide this application, we may very well say to the judge, Your Honor, even though this is a quite fast timeline, look at the harm that's at stake here. We have a life at stake. We have physical health at stake, or the survival of a business. These are the kinds of harm we might cite to. How long does it take for a mandamus action to be decided? Settlement usually will not occur within 3 months after the complaint is filed, but it could be a year or 2 years if the government does decide to fight the case. Won't the government simply deny my application or retaliate against me if I sue them? Again, this, in our experience, has never happened. Broadly, it is so rare as to not exist. So it's really, the answer is no. Retaliation, by and large, does not happen. That's not to say there's not one case somewhere you might find where there's an allegation of that, but in practice, it does not happen. My delayed application is with the U.S. consulate. Can I file a mandamus action against a consulate? The answer is yes, you can file a mandamus action against a consulate. The reason is a mandamus action is not challenging a consulate's decision. You may know that consulates their decisions are generally protected. If a consulate decides to deny your visa, it is next to impossible to challenge that decision. And that is because the Supreme Court has established a doctrine called the doctrine of consular non-reviewability, which says that courts will not look into a consulate's decision on a visa. Fortunately, a mandamus case is not challenging a decision. In fact, what a mandamus case is doing is asking the consulate to reach a decision. So you can file a mandamus action against a consulate. And judges do regularly tell consulates, you must reach a decision. Should I work with a lawyer if I decide to file a mandamus action against the government? I would say definitely yes. Mandamus lawsuits are complicated. It is complicated not only just to navigate the process of litigating against the government, suing the government, responding to the government's arguments, negotiating with the government's attorney. These are all very important aspects of litigation. But also, even before you file the lawsuit, it's important to talk with a lawyer to figure out if your delay is unreasonable. Because if you don't have a case, you don't want to spend the time to file a lawsuit, waste that time, waste the court's time, waste your time and your money. You really do want to make sure you have a good case before you take those steps. So with that, we haven't received any questions. So hopefully the presentation answered any questions you all have. Thank you for taking the time. Please do keep an eye out for that email from our firm, which will have a link to our YouTube channel, a link where you can schedule a consultation. You can see, we'll also share with you the presentation you see on your screen. Please reach out if we can be of any help at all. Thank you for taking the time today. We hope to be in touch.